we sat for dinner, and I asked Ido, what is the time slot that you are giving me? And from that question, it turned into a discussion about what time is the most horrible one. And I did a mistake of saying, and of course it's the first slot after lunch because everybody are gonna fall asleep. And I did a mistake of saying that you only put friends of yours in that slot because they cannot be mad at you. And I didn't intend it to be an advice, you know.
We can talk about it all like this. I have something to say about it too.
But I know it's tough, and it's going to be a bit more tough because the first advice of PowerPoint presentation is don't put a lot of text. But there is a lot of text here because I'm trying to show you historical sources, and I have to show them here. So let's make a deal. The problem with putting a lot of text is that the eye moves to the text instead of the speaker. So let's make a deal. I'll tell you when it's time to read and when it's time to be focused on me. And when we get there, otherwise you'll slip into reading the text instead of looking at my beautiful blue eyes. So much of the discussion regarding international armed conflicts ever since 9/11 has been as follows.
Mickey's a mouse, Donald's a duck, Pluto's a dog. What's Goofy? He's a dog. He's definitely a dog. He can't be a dog. He wears a hat and drives a car. God. What the hell is Goofy?
The analogy I'll explain, there's an international armed conflict, there's a non-international armed conflict, and there's this goofy conflict of, on the one hand, you are fighting a non-state actor, on the other hand, it crosses borders. So it drives a hat and it wears a hat and drives a car, and therefore it's difficult to ascertain what kind of category it falls in.
Right.
Now, that dispute or the goofiness of the transnational armed conflict was the basis of what has come to known as the torture memo, was the basis for their argument that the existing law of war does not apply to transnational armed conflict. And what was their argument? The existing law, as you can see from the Geneva Convention, had in mind two kinds of conflicts: interstate conflict, which are international armed conflict, and large-scale civil wars, which are dealt by Common Article 3, and therefore they didn't think about a conflict of the kind the Americans were facing, of a transnational armed conflict. And there's an historical narrative that is based on it, and the historical narrative says that the law of war has developed in 3 stages. On the first stage, it only dealt with interstate conflicts, with one exception. There were civil wars in which the state side, out of the kindness of their heart, gave the non-state side belligerency, a belligerent status, and once they have recognized belligerency, it was as if it's an international armed conflict. The second stage begins in the Spanish Civil War, meaning 1936, and then you have the beginning of law of non-international armed conflict. First customary, and then Common Article 3 of the Geneva Convention, meaning treaty law. And in the 90s, according to the American memo, there's a beginning of a 3rd stage in which human rights begin to apply to everything, and they are saying this stage is horrible, it's against state intention, and therefore we are ignoring that stage, and we reach the conclusion that because our conflict is novel, nothing applies to it. The same historical narrative is used by people on the other side. Saddam Muhammad is a recent English case that is still, it's now going to go to the Supreme Court, in which the court ruled that the British cannot detain individuals in Afghanistan without authorization of domestic British law, because there is no basis in customary international law for detaining people in a non-international armed conflict. Why? Because customary international law in a non-armed conflict is really new. So there hasn't been any time for a detention authority to evolve, and when there's a gap, human rights law fills that gap, and human rights law says that you need domestic law authorization. So the same narrative of, we have these two kinds of conflict. One is international, the other non-international, and transnational falls in the middle, leads to both kinds of conclusions. This is the narrative that I'm going to call into doubt. Let's start with the issue of belligerency. Out of the kindness of their heart, now it's the time to read. Now, I've specifically chosen an example in which the Americans are forcing someone else to recognize belligerency. And the conditions would sound very odd to you. Intensity of fighting, organization, and according to some approaches, control of a territory. Sounds familiar? Yeah, that's second protocol. There's a reason for this test in the second protocol. They were based on customary international law. So before we continue, one clarification regarding customary international law. We are all aware that when we talk about current customary international law, we are always aware that there are several approaches. And still we wouldn't say that there is no law, right? There's one approach, there are other approaches, but it doesn't mean that we can do everything. In the past, it was the same. So what I'm going to show you is an approach that was serious. It was applied. It was one of the approaches competing for the title of the customary international law of the time. And that approach regarding belligerency said that it's not a matter of discretion. Once certain conditions were met, you had to recognize belligerency. Now, it's all good and well in 1947, but look at the date here. 1699. This approach competed with the approach according to which there is no duty to recognize belligerency ever since the mid-17th century. And why am I saying that? Because Mackenzie, the greatest Scottish jurist of his time, is actually saying that King James had to apply that approach because that's the law in the Dutch Rebellion. So we have that doctrine being actually applied in state practice, including, by the way, in the American Revolution, American War of Independence, for several centuries. But belligerency, who cares? Belligerency is dead. Nobody recognizes belligerency anymore. Let's talk about insurgency. Insurgency is civil war in which belligerency was not recognized. Now, we have been told that the law regarding such non-international armed conflict began in the Spanish Civil War. Do you see from what time is this? So what is Wilson's conclusion regarding customary international law in 1900 in a lecture given, again, I'm picking intentionally American example. So he's an American military lawyer. He's giving his lecture in the American Naval War College. And here is his conclusion. In recent years, the practice has been to admit in revolutions the conditions of hostilities prior to and not carrying with it the full rights of belligerency, which may be called insurgency. And in insurgencies, it may be said to be established that the parties to the conflict that attain the proportion of the insurrection shall observe as far as possible the rules of civilized warfare, meaning the same laws of international armed conflict are observed as far as possible in what we call today non-international armed conflict, including the protection of civilians. What they were not given is the status of POW. And that is 1900. Now I'm going to surprise you a bit.
Just a clarification, because the POW has not been developed yet? Or
No, because it wasn't religious. That's the difference. But the other, like using poison, attacking civilians, and so on, as far as possible. Now, people, when did the international criminal law begin? You're a friend, so don't answer. When did it begin? World War II, right? Nuremberg. Earlier? When was the first international criminal tribunal? Nuremberg? No? Earlier? The accepted narrative is Nuremberg, but what I'm going to show you is there's a longer history. What I've done regarding the international crimes, I've showed that there's actually nearly a millennium of continuous history from ever since the late Middle Ages, perpetrator of war crimes as well as early notions of crimes against humanity and aggression were regarded as enemies of mankind and international outlaws subject to universal jurisdiction. And you can see it in a top secret memorandum from 1944 saying that for the past century at least, it's actually a millennium, perpetrators of war crimes have been treated as enemies of mankind, hostis homine generis, which is enemies of mankind in Latin, and international outlaws. That's all good and well, but still, we are dealing with non-international armed conflict, and also we have the issue of international criminal tribunal, which is the narrow sense of international criminal law, which that surely had to begin only in Nuremberg. Let's see. Boxer War is a rebellion in China with anti-colonialist motivation. They are butchering Europeans, but more than that, they are butchering 30,000 Chinese Christians. So that's genocide. So in a joint, now the legend says that the term crimes against humanity was born in the joint letter of protest from 1915 against the Armenian massacre. This is from 1900, meaning 14, 15 years earlier. And how do 11 states describe the actions of the Boxers? Crimes against the law of humanity, against civilization, and in some sources it's also against the law of nature. Now they do more than that. A joint military force of 8 countries is dispatched to China to take down the Boxer Revolution. They are not fighting the Chinese government. They are fighting the Boxers. So we have an international coalition fighting what? A non-state actor, right? I thought that the law regarding that only began recently. And here you have
There was a colonial undertoning.
it's all good and well, but the basis, the legal basis was, by the way, regarded upon in World War I as a precedent for the proposal there. That's it. An international military tribunal with judges, British, German, Italian, and French judges, had tried some of the leaders. And by the way, it's not the only tribunal, international tribunal from the Boxer War. So we have an international criminal tribunal in a non-international armed conflict. And it's not the only one. You have one in Egypt 2 decades earlier. You had one in the Archangel intervention in Russia. You have one in the Balkan War. So not only you have law of armed conflict in non-international armed conflicts much earlier than the Spanish Civil War, you even have international criminal law in the narrow definition of it, like of international criminal tribunals in non-international armed conflict earlier on. Now another interesting example. We have a kind of a non-state actor that is unique, and that is all sovereign entities outside of Europe. A state is a European invention. It was forced upon non-Europeans gradually. But prior to that, you had tribes, empires, princedoms, whatever, and they weren't states. One of the examples is the Native American tribes. And this is the first treaty to be signed between the US and a Native American tribe. It's the Delaware tribe, Delaware Nation, in which there's the option of the Delaware Nation joining the Confederation. It was then a confederation, not a federation, as a state. Becoming a state and joining the Confederation. So they treated this sovereign entity as an equal of a Western state. And they create an international criminal tribunal for the enforcement of breaches of the peace, of breaches of truth, which, by the way, was a common practice in Europe as well. So you have the idea of creating an international tribunal of judges from the Delaware Nation and the Americans, and this is important, based on the law, customs, and usages of the contracting parties and natural justice. Natural justice is the law of nation. Joint customs is the adaptation of the idea of the law of, so natural justice is the law of nature. Joint customs to a non-Western entity and a Western entity is a narrowing of the idea of the law of nations. In customary international law and natural law-based international law, as it adapted to an interaction between a Western entity and a non-Western entity. So the basis for that international criminal tribunal is international law. And Martins in 2007 says exactly that the treaty provides for the establishment of an international criminal tribunal consisting of members of the Americans and Delaware nations. Now, this is peacetime, but the same idea was applied to war. So similarly to what we have in non-international armed conflict, where we have a competition between a doctrine that's saying that there's nothing, that there's full discretion, and a doctrine that says that the law of war needs to be applied as far as possible, you had the same dispute in wars between Western and non-Western nations. So you had some applying a doctrine saying it's total war, the Germans in the Boxers' War, and some applying a doctrine of saying you need to apply as much as possible the existing law of war, the Americans in the Boxer War. Yeah, but
because they had laws for civilized war and laws against the bar.
So the Roman law served as inspiration, but the actual beginning of these ideas is the trauma of the religious wars. So they take the doctrine that existed before and expand the limitations on the law of war because of the trauma of the religious war of the 16th and early 17th century. So you have throughout the late 17th, 18th, and 19th century a dispute between one position that says nothing applies and the other position says as much as possible, both with regards to these kinds of entities and with regard to civil war. And just so you see that it's a similar doctrine, Marshall, Chief Justice Marshall, when he needs to interpret that treaty, says, as near as it may be to the model, again, it's the same idea of approximation. Now let's play a game. Transnational law is said to be novel because A, it's a war against non-state organ that crosses borders, and there's an issue of technology that creates that situation, and there's a blurriness of the distinction between war and peace. Right? Once upon a time, there were clear-cut declarations of war and peace agreements, and now everything is blurry, and a blurriness of the distinction between combatant and civilian. Right? That is why transnational wars are new. So let's play a little game. I'm going to give you a text, and you try to guess when was it written.
A long time ago.
If you didn't have the introduction, right? It looks like a text written today. States are irrelevant no longer because of developments in communication and so on. You have networks crossing borders, and even in conflicts, the states are irrelevant. And he is right. World War I began because of a non-state terrorist organization that crosses borders. Serbian nationals trying to break apart the Austro-Hungarian Empire. That's, at least if nobody believes the Austro-Hungarians, but that was the declaration of war saying. When was this text written? Try to guess.
Modern times within that context.
Oh. When was this the most burning issue of the day? Now let's play that unprecedented game, right? We already saw that the torture memos called it a novel war. Now we have also the terms unprecedented and a new war. Notice that they are stressing specifically that it's not another Greek civil war. Now that's McCormick writing an article that was influential in bringing the Truman Doctrine, series of op-eds that were influential in bringing the Truman Doctrine. Does anybody know what the Truman Doctrine was about? NATO. Because there was a concern from non-state communists and an international network of non-state communist organizations that are going to topple all governments in Europe. What's nice about the speech of Roosevelt, it's the four liberties speech, is that he's going through every war that the Americans went through from the American Revolution, and saying none of them were unprecedented. This is the unprecedented one. And what I'm showing in the article, that each of them has a speech saying it's unprecedented. World War I, the Boer War. This is my favorite. All wars I remember were unprecedented. The American Civil War, the Napoleonic War, and this is a serious treaty. That's the treaty that determines the detention of Napoleon. The War of 1812, the French Revolution. 200 years of unprecedented wars. And there's a reason. It's a known psychological effect. crisis of our age is somehow more critical than the crisis where we are in. We like to think that we are unique. People, we are not. We live in one of the most boring periods regarding warfare ever. To quote an American president, an American has a greater chance to die from sleeping in the bathtub than dying from a terrorist attack. Now I know that in Israel, I don't know the statistics, but it's greater. And still, if you compare it to Europeans in the 19th century spent 20%, 25% of their time in war. In the 18th century, 38% of their time in war, and in the 17th century, half their time in war. The period now is the most quiet period ever in the history of mankind, at least in half a millennia, if not more. Mundane time. Celebrate boredom. Stop inventing excitement when there are no excitement to invent. Now, Mary Kaldor is the big kahuna of the new war position, and after being criticized for lack of basis for her argument that we are fighting a new kind of war, she published an article in 2013, and what is she saying? The people that are guiding me are right. Calling it a new kind of war is simply a good way to clear the table from old paradigms. But it's not new. Yes, and she's then saying technology, blah, blah, blah.
No, she's not saying, okay, I just want to care that publish again and again,
Yeah,
and it's going to the garbage. It's not.
Is she saying that?
She said there is a new war, but
What
for the sake of the argument.
No. What she's saying is that these wars have existed always, but we focused on other wars. That is what she's saying, and that is not right. Even the matter of focus is not right.
Quick question.
Yes.
When you're saying that we are living in a boring time.
Yes, mundane.
Mundane, yes. You mean Europe and the US?
No. Even in other parts of the world are relatively.
So you're looking statistically at.
Yes. So, for example, non-international armed conflict, civil wars, wars on the rise from the mid-80s to the late 90s, and even they are in decline. It's true that Europeans are getting the frosting of the cake. If Europe traditionally was the bloodiest area in the globe, they are enjoying the most quiet time in centuries. But even in generally, even in other parts of the world, it's much more quiet than it is.
But is it an increasing line, or it used to be high, then moderate, now we're
Europe, it's clear that it's decreasing.
Yeah.
Other parts of the world, it's fluctuating depending on international politics, but the general trend is declining throughout. And the reason I've given these examples is because all these unprecedented are for similar reasons. It's always technology, non-state actor, atrocities, and if it's border crossing non-state actor, it's of course not. Like Napoleon. What was Napoleon? When he runs away from Alba, he's not the head of France. What is he? And his aspiration is to create a global empire. A head of a formless political entity. What is that? If not transnational, non-state actor. Now's the deal. Here's the deal. It's nice to go to history. So good and well, but we have Article 3. Right? Article 3 does a clear-cut division between non-international armed conflict, which have all the Geneva Convention, and non-international armed conflict, which have only Article 3. Right? The treaty does the clear-cut division. This nice, as far as possible doctrine died in 1949, right? Everybody in Israel knows this schooling, right? Semel, always cited for occupation. Here's the story. Israel goes into war in Lebanon against whom? Against the Lebanese army?
Against Hezbollah.
No, then it's the
Fatah.
That's Fatah. So it's a border crossing war against non-state actor, right? It starts detaining warriors of the non-state force. They are petitioning the Israeli Supreme Court, arguing that there isn't any authority to detain them. Sounds familiar? Saddam Muhammad, right? Now, we all learned that the Supreme Court in Israel says that that there is an occupation, and therefore the law of occupation applies. But actually, the Supreme Court says that it doesn't matter if it's only an occupation or not. Why? First of all, let's see. If it was like the Supreme Court is saying that he's dealing with individuals carrying arms that are not among those eligible for POW status. So if it was the current dispute, what would you expect that the Supreme Court would rule? That there are unlawful combatants, and therefore, from they being unlawful combatants, there is authority to detain them. That's the American approach. What actually the Supreme Court is ruling is that the law regarding detention in occupied territory apply even though it's not an occupied territory. Why? Have you met this as much as possible approach? There's a duty to apply as much as possible the law of the regular law of war. And once the Israeli government has decided that it's not going to prosecute them and it's not going to give them POW status, the only law that remains is detention in occupied territory. And since it's not an occupied territory, you need to apply that law with the necessary adaptations. And look on what they rely upon. What country's law of war manual?
I don't know. Did they use the mountains?
Yes, he alludes to the mountains. So they had the 1958 British law of war manual that says that the law of occupied territory needs to be applied as much as possible, even in areas that the troops are passing and even in the battlefield. The Americans' understanding of the as much as possible doctrine was even more expensive because they gave POW status to non-state actors. Here is their approach in, you see, the as much as possible, but let's go to that. Here is the American approach in Vietnam. Any guerrilla who was captured with weapon in battle, no matter if they pass the criteria of the Geneva Convention or not. Because the criteria are quaint, and it's not right to apply them strictly anymore because they don't fit the situation, so you apply them by analogy as much as possible. This was the American policy from 1949 to 2000, including in Korea, Vietnam, Panama, Somalia, Haiti, and Bosnia. Now you may ask, how do I know that? The torture memo lists that this was the American policy a moment before they shrug it away as a matter of policy and not a matter of law. But the Americans did not regard it at the time as a matter of policy, but as a matter of law. That was the doctrine. See, look at the Israeli case. Shamgar rules looks at it as a legal doctrine. It wasn't a matter of policy. Now, you remember what was the conclusion of the Americans in 1973 from the idea it's quaint. Because it's quaint, we need to adapt it as much as possible to the current conditions. What do the torture memo do instead? Because it's quaint, we toss it aside. Now they had even greater audacity. In the same memo, in which they toss aside all half a century of legal policy, simply a matter of policy that can be cancelled, they say that they can prosecute Taliban and Al-Qaeda fighters for war crimes simply because the American president, as a matter of policy, can apply international criminal law. Sounds like fair warning, basic notions of like that reasoning for international criminal law fails the benchmark of basic ideas of morality. I'm telling the enemy that I'm prosecuting you because I feel like it. Now put that aside and focus on the fact that it contradicts a memo published by the American government 2 months prior. Now I know that you're tired. It's the last memo. It's the last slide. Please read. Please read it. I promise you, you'll benefit. And look at the date. It's 2 months before the torture memo and 2 months after 9/11. What are the precedents being relied upon? So when did the as far as possible approach die? 25th of January 2002. It was still applied by the Americans on November 2001. But the torture memo framed the discussion around the relationship between Article 2 and Article 3, meaning the distinction in treaty law and customary international law, and I'm going to use my favorite word, customary international law, because it's murky. God forgot. The end. Yes.
I have a bit of a cheeky question. I'm sorry. And it is this. Does anyone really stand for the proposition that a legal vacuum applies in the situation of the discussed situation for differently? I don't think that anyone in his right mind, including the United States, stands any longer for this proposition. So maybe it's a bit unfair to be portraying this position. I'm not, God forbid, saying that there was no such debate and that there are certain people.
This is why I get suddenly funny.
Yeah.
Because the same historical narrative is the one that is used to insert, like, by mass, international human rights on the side.
Yeah.
Even though you have norms that have developed in the law of war to deal with it, that are equally constraining, but simply deal with the issue better because they were adapted to it historically. the importance of the torture memo is not the position of the torture memo, but the fact that they framed the premises of the current discourse. The premises of the current discourse, and I'm losing my mind every time that I tell people start it. Is it a nayak or a ayak? It's like once you start the debate with this hair splitting, like it has to be that or that, that is what the torture means. You know, they frame the discussion as if there are two pristine forms of conflict, and everything that does not fit, we are faced with a problem with regard to, and then we have lacunas in the law, and we need to fill them in this or that way. And it's not that like being against in human rights versus being against puppies and rainbows. How can you be against human rights? My problem with human rights was that it did not develop to deal with this situation. Law of war is duty-based norms, and there are advantages to duty-based norms as opposed to right-based norms. One of them is that a person cannot sit on his duties. And people and civilians in international armed conflict are weak. They cannot demand their rights. But if it's a duty, I can demand it of you, irrespective of whether the victim had complained or not. Moreover, there are imperfect duties. There are duties to aspire to. And I can demand you to do reasonable steps to aspire to, but nobody can say it's my right because it's an imperfect duty. So a duties-based discourse, which is the discourse of the law of war, have advantages over right-based discourse.
Oh, this is a point that I got help me fully subscribing blindly. So I absolutely agree. Common Article 3 is coterminous to some of the non-derogable human rights, and it is absolutely true. Some even go far further and say it's a Hughes Coggins kind of thing that you can't really derogate from, and so on. But my point being is, I think that we need to draw a line between what, and putting Saddam Muhammad to one side for a moment because it's relatively new and not yet over. So maybe,
I hope that
I don't think it's yet over, so maybe we should put a pin in that one for a moment. But the point being on the way that, on state practice, as it were, and state declarations on this point, interestingly enough, you may find completely different views in other places. For instance, you may see implied or rather straightforward concessions by Russia and the US and Israel in official positions before, let's say, the United Nations General Assembly 6th Committee on the point of discussions from November 2014 on the effects of armed conflict from treaties, where everyone talked in terms of tonnage. People were not talking about Common Article 3, yes, no, Common Article 2, yes, no. They were all like, oh yeah, protracted and this and that, and naming tonnage and ICTY in so many words and saying this is the customary or closest to customary definition. And if the ILC does not go by that when it discusses the effect of armed conflicts on treaties, then we cannot prescribe to the ILC article from this point. So maybe the state practice should be to some extent separated from what the blah blah that the Bush administration put forth with respect and what states are actually saying on legal points on this point. And it seems to me that we have somewhat moved away, thank God, from this artificial segregation between this and that, and people are now, are thinking in kind of tonnage terms.
So first of all, the division into three phases. The historical narrative that both Saddam Muhammad and the torture memo rely upon appears in tonnage. Okay, so even there it appears. Secondly, well, the problem begins with in two ways. The Americans even today, after making many concessions, are still saying that there's nearly no customary international law applicable in the conflict. And their ability to do it is because the general doctrine, the as far as possible doctrine, got lost. The idea is to reinsert, because it's not long ago, it's 15 years, general doctrine was a doctrine that propagated new development. It's not, okay, one norm, other norm. You need it in each conflict to adapt to the conditions of the conflict as far as possible the general law for. And that's what was lost. The general rationale, the general mechanism that propagated new development. And where you find it, another place that you find it is that the discourse is shifting toward human rights. And the problem, and you see it in the petitions in Europe, in the American Commission, in the UN Commission, and so on. And once you frame it as human rights, things get lost in the translation between IHL to human rights. And I'll give you an example. I started writing on the problem with applying human rights because I was asked to respond to two new judgments of the European Court of Human Rights. And what's nice is that I didn't choose the verdicts, and in both of them, if you were to apply IHL, the people would have gotten greater defense. And I'll give the cases. One case was Hassan. The guy was arrested, released, and found dead 7 months later. The European Court of Human Rights said, 7 months later, there's no responsibility, you are scot-free. But you have a duty, according to IHL, to bring the person safely to his home. They dropped him 12 and 1 minute, 12:01 at night, in the market near his house. In Basra, I doubt that when he walked the 100 meters to get to his house, he succeeded to arrive home. If you would have done it through IHL, they wouldn't have gotten scot-free. The other case is the case of Jalud. In that case, there's a shooting. There are many forces, and a person dies in a roadblock. And they take it to all these ideas. There's jurisdiction and so on. IHL is simple. You are a commander. You are in charge of the operation. There's a suspected death in the operation. You are the one that have the responsibility to investigate. It's a duty. It doesn't depend if the family has money to turn to the European court and the court needs to invent all this jurisdictional nonsense to get to the point that in IHL is very simple. And the reason that we are going there is because the discourse, once the Americans emptied the discussion for everything that is not clear-cut, pristine treaty law, the vacuum began to be filled with human rights law. But if you understand that the law firm was always much more rich with all these customary norms, you understand that the voids and gaps are much smaller. There's much less need to fill it with number from outside. That again, I'm all for human rights. I'm simply saying that the law, through experience, developed to deal better with this situation.
I didn't even say God forbid the more.
No. Puppies, animals, and human rights are things that you cannot oppose, but still, sorry. What's next? Sorry? What's next? Puppies? I'm going to write that against puppies?
No. Saying either every war is unprecedented war, or there's nothing new. What's your approach?
So, every emergency is unique. That's the only thing that is permanent about emergencies, and I'm sorry to raise Schmidt again. The only thing that is permanent about emergencies is that they are unique and unexpected and so on. But the fact that you have brothers and sisters, right? Each of them are unique, and still all of them are wasn't fights. The same with emergencies. It's or wars. It's the fact that that each war has unique attribute does not mean that the law cannot be applied to it. It needs to be adapted as far as possible. Exactly what this old centuries long doctrine aspired to do.
Yeah, Kim. No, Robert, please. Okay, sorry, one terminological point that I was wondering on, you raised the point of the distinction between laws of nations and natural laws and so on. So I am a bit skeptical. I'm also big on the historic research of this. And what I found is that, at least that's my impression, that many times when states have used the words civilized nations and they expressed civilized something in laws of the nations, they were not talking in what we today in modern terms would call customary international law. They were kind of, I don't know how to call it, daf misarim, I don't know, kind of reading of, you can find it in John Quincy Adams writing, Thomas Jefferson, and everyone and their grandmother, whenever they opened their mouth, it was always by the laws of the nations, and as civilized people and nations always do, and so on and so forth. So to what extent would it be fair today to, when looking at it, calling it like pre-existing customary international? I think with a bit of slight grain of salt.
So 2 grains of salt and 1 grain of pepper, okay? So I'll explain. Even today, open 5 papers regarding IHL, you get 5 positions regarding what is customary international law, and it's the same today as it was 200 years ago. The terminology was a bit different, and it's on 2 levels. On the first level is that the different people have used the terms law of nation, law of nature, law of humanities, law of civilization differently. What you shouldn't do, not today and not then, is to pick one article and say, that's the law. The law is discursive. The law is not what I'm saying is the law and not what you're saying is the law. It's somewhere in the middle, in the sense that when I'm going to act, no matter what I think the ideal law is, I'm going to take into account the other serious positions in the discourse. And my actions are going to be somewhere in between, like this smash of taking into account my ideal legal position, my particular case-specific interests, and the other positions, legal and political positions in the discourse. All this smash would influence my actions. This is today the case. When you write a legal advice, you're not writing your ideal. As a practitioner, you're not writing your ideal legal analysis. You are taking these issues into account, and this is what they've done a century ago and 2 centuries ago. And therefore, when you look at customary international law, you need to do 2 things. First of all, do not assume that there's one position that is the law. There are several positions that are arguably the law. Secondly, you need to look at actual practice, not what people say. This is why I brought you the Boxers' War and the treaty with the Delawares and the Dutch.
Weight of all of these statements, and I'm saying that
this is why I didn't bring you Portis. I didn't bring you Vatel. I didn't bring you Chris. I brought you Halak
Actually, Vatel was big. Did not distinguish between the 2.
Yeah, I know. But I would bring you the letter that Vatel wrote to the city council in Switzerland, because that's practice. Because when he's writing his law book, he can go roam to the fields of theory and his pure legal analysis. When he's working as a practitioner, he needs to take the other views in the discourse. And this is why when I did the research on the history of international criminal law, and here as well, I'm looking at actual practice, while still saying this was not the law. this was one of the positions that was arguably the law, and there were periods in which it enjoyed greater support, and there are periods in which it enjoyed less support. I'll give you an example. The belligerency doctrine, 17th century, it's impossible not to get belligerency. Early 18th century, it weakens because of the British deciding the Jacobin Wars to do as they wish. Late 18th century, again, it's almost impossible not to recognize belligerency. It's unimaginable. This is why both in the American American War of Independence and a bit later, even in the
Alabama Constitution.
Yeah, but there it starts to weaken. But in the Mexican War, in the Texan War, you see it recognized still, which is 32, something like that, 36. Late 19th century, the belligerency really weakens. 30s becomes strong again. 50s, it's iffy. So you have support for the competing positions fluctuating over time. And it's the same today. That's the nature of the legal discourse. So I'm never saying that's the law. I'm saying it's an approach that enjoys considerable support, and we should consider readopting it because it has benefits.
Trying to organize my thoughts here. One thing I want to tell you, first of all, it's amazing presentation. Makes you really wonder about very basic issue that you once again about law. About the mind. One of the you have to differentiate between rhetorics as all these specific lines that people think that it's a new word, a new word, a new word. We know that. Let's put it aside. Rhetorics is something that's usually used, but doesn't bring me too far. Then you have military assault. And if I understand correctly, America goes still thinks new words, new wars, and she doesn't. She always wrote there that okay, you can understand it's a new word, it's an old word. The important thing is that we can speak about it as new dimensions to the war. It is something that we have to take into consideration. There is no rhetorics, no military assault, law. And law, as it evolved over the years, and again, this is the issue, the belligerency was one of the main issues topic, made these gaps in, for example, the Martin's Clause was talking about that was the outcome of not agreeing on the belligerency status of the frontiers in the 19th century.
And what does the Martin Clause say when you read it?
Exactly, nothing.
No. Exactly everything. Yeah. And I'll explain. Wait. I want to stop you here. Because the Martin Clause is as far as possible doctrine, or actually the next wait. So every time that you read the Martin Clause, you get only a section of it. You get that until blah 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 would be more clear, the principles of law of nation as they apply, blah blah blah. First of all, go to sentence 24. Okay. It is not remain to the complete discretion of the military commander. Meaning it's not something general and instruction to the state. It's structuring the decision making of the military commander specifically. And wait, there's an issue here.
I haven't got to the end.
And now go 2 sentences ahead, and they are saying this is specific, especially an instruction with regard to Regulation 1 and 2. Regulation 1 is regarding the eligibility of POW status for irregular forces. Regulation 2 is the eligibility of POW status for civilian fighters. So specifically with regard to non-state fighters, you have the instruction not to treat the situation as if it's void of no.
Specific issue about the Martin told it was taken out of context afterwards to overrule IHL as a whole, and that's, I think, it will never do. The thing is, what I would point to at is that from the beginning of the modern IHL, the idea of separating or between rights in certain conditions as to Belligerency or as to other kinds of war was something that was going all over this. You have additional protocol 1 and additional protocol 2 because there was no agreement on all rights that you want to give during an armed conflict, which is MAC or IAC. Another way of saying it is that history made the American claim come true, which is a wrong claim. I agree with you with the analysis. Of course, there's no total vacuum on that, but it's not the Americans that invented it. What brought this claim was century of making this gap. It was always disagreement about certain rights of certain conditions of while waging war.
So I'll start with a story. I had a BA in psychology, and my greatest professor was here, Breznik, and he said that when he was a student, and he asks, don't understand from this that I'm saying. Now I realize it maybe understood I'm calling you crazy. So no, it's not the interview.
You're wrong. You won't be the first.
You
There
won't be
was-
wrong. You won't be wrong by that.
We know we go long back, so don't
Everybody-
understand the story like that. He was taking care of a schizophrenic that saw that he was two generals at once. One of Napoleon and the other 100th century later, and the difference was that the head, when he was like that, it was the Napoleonic general, and we switched it like that, it was the general that was 100th century later. And when he thought that they got to the level or a high level of trust, he asked him, how can you be two generals that are in one century gap? And the person told him, so you also read their history. And from that moment, he talked to me anymore. So I'm gonna, of course, continue talking to you, and I'm not calling you crazy, but you are reading their history, and I'll now explain. The development of the law of war was always in two tracks: the treaty track and the customary law track. The treaty track, by the very nature of treaties, by the very nature of written law, does these divisions. And one of the oldest tricks in the books was for someone, when it was not convenient for them to apply customary international law, to say all what we have is what is written in the treaties. But if you look at the treaties, all of them, when they got to these issues, to the issue of classifying people, classifying conflict, they always say, we are not regulating the whole issue. We are adding a patch. The whole issue is still regulated by customary international law, and I'll show you it in Common Article 3. At a minimum. It's not, maybe there's more. But we have decided in this treaty to say that this is at a minimum what we need to apply. And that's the difference.
Why would you need to do that?
Because of the discursive element of law, meaning I'm pushing one of the approaches that was in the discourse. The other approach that they were trying to prevent is exactly the approach that said that there's nothing. So they were saying we're not going to agree that our approach the more expensive. We are not going to set aside our more expensive approach, but we are going to prevent from you for putting the total war approach. That was the aim of Common Article 3. And you see it in the after the list of provision, they are saying you need to apply partly or fully the rest of the law but we allow you to make it depend on an agreement with the non-state party. The whole way that Common Article 3 is framed is to abolish the total war doctrine. It was not intended to rule between the disputes regarding the other positions, and there were actually two other positions. There was the minimum of that humanity demands, minimum standard, and as far as possible.
The adequate, there is also some talks about the adequate. You were in the middle, I don't want to interrupt you.
So it's always the difference between treaty law and customary international law. And once the discussion is framed only with sight on treaty law, and we have this tendency, it's a tendency, Watson, surely, lawyers go to the most accessible legal source. Not the most correct, not the most efficient, not the most right, the most accessible. And treaty law is always more accessible than international law. And this is why it's easy to frame the discourse be focused on treaty law.
What I'm trying, first of all, I agree with what Prof is saying. What I'm saying, it is not the Bush administration intervention that the Bush administration intervention, there's no lacuna, there's nothing applicable here, was an outcome of a centuries of making this progress of trying to put, okay, it's an IAC, which is, and trying to fight the differentiating, the difference. You can go with that far before, and this is just Bush came and just threw it on the board.
So here is where we disagree. You are right. There were people in the discourse prior to the Bush administration that were saying there's a clear-cut division between two kinds of conflict. By the way, Pictet.
Okay.
But Pictet also wrote all the fuzzy, all the murky situation. We need to aspire to apply what we can. So Pictet was first a continental analyst putting that here is the clear-cut division, and then dealing with all the unclear situation. But if you would have, but there were serious people in the discourse, serious positions in the discourse, and I'm talking about the American military, and I'm talking about the British manual, and I'm talking about Shamgar line on the British manual, that would have looked down at you if you would have tried to start doing this parsing of categories. They would say, no, war is by the very nature messy. No war, there isn't any war that fits the condition. They were also addict to the unprecedented and saying, the war of today, us. You cannot, and this is why you have to, as far as possible. And that voice within the discourse got quieted down.
Again, the notion is that the states were so concerned about others going inside what's going on in their country, and the force they're using in civil war. That's the marital law discussion was. It is I don't recall the name of the one she was answering to. He was saying it's new. It's not a new war. It's just a new. These are the new civil war. We have new. We the same pattern of all civil wars, maybe changing a bit, but it's not an era. We had civil wars before. So the what really happened in my opinion is I agree with her that Bush took it one step too much and to the extreme. But for centuries, 100 years, countries were very concerned about others from the outside messing with what they do inside the country, with the autonomy of the country. And this is why they made different laws, very extensive laws, relatively to international armed conflict, a very narrow approach as to things that are going on in their country. So what happened at the end was the progress related to that extreme that they had to take to be pushed to push it on the.
Robert, so here's the deal. You are right that this was one of the voices in the discourse. You are completely right, but it was never the only voice in the discourse. When always it became the strongest voice in the discourse? During treaty negotiations. Because treaty negotiations, first of all, are statist by nature, because only states gather around the table, and you need to reach an agreement on the lowest common denominator. So once you have in each period few states that are saying, no, nobody interferes in our turf, it doesn't get into the treaty. But if you look at actual practice of states, you'll see that you are completely right, there were these voices. But there were other extremely strong voices. For example, Spanish Civil War. If you open the law books of the Spanish Civil War, you see that the main attitude was the as far as possible doctrine. You have article after article saying it's obvious that the law of war applied. So when Cassese comes and says there is customary international law in the Spanish Civil War, it's because it was one of the periods in which the support for the as far as possible doctrine was the strongest, to the extent that the application of the law of war to air bombings mostly developed in the beginning, developed in the Spanish Civil War, and nobody thought, okay, it applies in NIAC, so it doesn't apply in NIAC. It was obvious to them that it applies in both. You are completely right that it was one of the voices in the discourse. And it's a voice that was always more pronounced in treaty negotiations. But there was another extremely strong voice, and what's important to understand that there was, look at the Spanish Civil War. It crossed borders. There was attacks at the time all over in the Mediterranean that were defined as war crime. It was perceived as a war between two transnational ideologies. You had, if we're talking about foreign fighters, you had the International Brigade, meaning you had people pouring into Spain to fight this war between two universal ideologies. It was nothing but a simple civil war. And I dare you to find a simple civil war. Now look at the classical interstate wars. World War I began by the action of a border crossing non-state organization, and the variety of non-state actors, from tribes to state to be, meaning forces of national liberation, to sultandoms, to rebels in South Africa. The diversity of non-state actors fighting this war that we tend to imagine as a simple war being fought in the Ardennes, we are constructing we are simplifying it in history, in retrospect, and marginalizing the elements that don't fit into the simple category of NIAC. But these are the complex war that raised the same issues of non-state actors, of border crossing fights with non-state actors. You had in the American Civil War, both sides are signing treaties with Native American tribes as sovereign nations, and they are fighting both sides. And after the war, the Union needs to re-sign treaties with all these tribes, because the war voided the old treaties, and some of the wars with some of the tribes continues until 1898 with POW status. They are giving these bands of Native Americans POW status. Yes.
I have a methodological question to you. Trying to combine the two mentioned it first. So, so the three elements you're working with. One element is an understanding of principles or standards of customary law and their relationship with treaty law. So that's a positive, non-positive distinction in or relationship in IHL or international law larger than IHL, because by definition it involves also human rights. And that's it. This is methodology number one, which is to what extent we accept principles and the relationship of principles versus positive law. Is it exclusionary, non-exclusionary? The second methodology or variable that you introduce is the temporal variable. And here you say, contrary to our intuition. So you have contrary to our intuition. Usually we say positive law displaces principles. You're saying no, it doesn't displace the common law of nations, but it has a very rich relationship with, so positive law has a very rich relationship with the common law of nations. So this is one intuition you try to display. The second intuition you try to display is the atemporal aspect of law, which means to the extent that this is the law of belligerency, it is the law of belligerency, and you say, no, the law of belligerency actually reflects
a discourse.
This is the third element. This
Okay.
actually reflects the relation between positive and non-positive and other variables. But it changes over time. So the law of belligerency in point A is not necessarily the law of belligerency in point B, not because there was a positive intervention. On the contrary, which is what we would think. We would say, no, it is because of perception. So it's a temporal perception that we should be mindful of as lawyers. To tie back to this notion of perception, what we think of. Okay, so we have the ebbs and flows of the law because of what people think other sources of law do. And the third element that you bring to methodological element you bring is this notion of discourse. We tend to think that the law is somewhere out there, but it is the law. We might not know what it is, it might be vague, but there is an entity, ontological entity somewhere out there that we can grasp. And you're saying, by definition, we should reconceptualize our understanding of the law, because the law is discourse, which means that there is I hate to bring the uncertainty principle and the cat and again to our, but the cat is present. Let's say hi to the cat. Okay, the law is somewhere, and we can never know where, is somewhere in between the discursive positions.
Yes, but it's
by
not,
definition, it's an ontological perception. It's an ontological fact, so to the extent that we can talk about the decision and facts and norms here, but it's an ontological fact that the law is somewhere in between the discursive positions. Okay, so you have three points here: the temporal, the ontological, right, and the relationship between the positive and the non-positive. So this is what you're asking us to work with. Okay. On the methodological. Without going into the details of whether it is a political manipulation by Bush or whether it's actually a reflection of the deep history that came before Bush, and without delving into the notion of what is an emergency by definition can law capture an emergency by definition, or is an emergency by definition outside the law and therefore cannot be fully grasped by the law? Let's test your methodology with respect to terrorists, discussion of terror, and whether terror is a third category. Because what does terror do? Terror says the war on terror, to the extent that we buy this expression, is ongoing. It's here to stay. It's a war between wars. So you have high ebbs and ebbs and flows. So sometimes you will invade Afghanistan / Pakistan / wherever you want to invade, Iraq, whatever. And sometimes we will continue the fight against terror with drones, we've heard about with drones or by other means, but it's the same war. It's just the war on terror, which is a unique type of war. Okay, if this, so what the three elements that you're talking about? Positive versus non-positive. Do we care about the treaty? We just heard that treaties are important. Or in the absence of a treaty, we have those principles. So what should we take those? And again, the temporal ebb and flow and the discursive. So now I want to know, this war and terror business, is it a third category that I have to think about in terms of new things that are, or it's the same IHL principle that to the best is best possible, whatever it is, or let me just apply them and.
So okay, so the answer depends on what's my role. So if my role is to assess the law as it exists today, I would have to say there are, write an article, we start with saying there are three positions and so on, okay? If I'm trying to advocate, and I'm fully admitting that I'm advocating for a specific position within the discourse, I'm going to say, look, there is this position that is long-standing, has been tried and tested, has been wonderful. I would say the best invention since sliced bread, but it's older than sliced bread. And I would push the position that I support within the discourse. If I look at it,
knowing that there will be a counter position in the discourse, and the law will be somewhere in between.
Yes. Which exactly how an article usually is built. We present the different positions within the discourse, and then we'll say why our position is better. What is my rub it down the sleeve is that I'm saying that I'm taking some of your arguments and saying, come on, new. Everyone said before you, it's new. Like that, I'm pulling the rug of the unprecedented, of the new, it was never been tried. We have to do something else because there is a vacuum. That element I'm pulling, that rug I'm pulling from your feet and from under your feet. So if we're going to now I'm going to go back to your division of three elements. So regarding the element of treaty versus customary, I'm full supporter of European customary. I'm saying that treaty is good. Treaty clarifies elements, but never, to this day, despite the first attempt to codify the law of war being in 1874, to this day they never succeeded to codify the law of war because of the discursive element and because of the nature of treaties. So I'm a full supporter of
codifying. They say
they always say
they develop.
No. Look at the full title of the Hague Regulations. The law and the law and customs and usages of law, they are completely playing the game of we're not doing anything new, we're just codifying the existing. So
still saying that the law have to be evolved until the such war.
Okay, I'm having problem with that. I'm not thinking we're evolving anywhere. We are changing. I'm developing, but developing is even. There's an element of positive to it and changing, but I have a problem with anything that attempts to say that we are evolving everywhere. So I'm all for looking at customary law. I think that the law is the life of. There's an element of experience and so on, even though it's not precise, even though it's discursive, I think it's important to look at the customary element. So that's the relationship positive and customary. When we get to the temporal, I think that we have been put within, what the whole says that we see only, we are Western, statist, and so we first are educated to be domestic lawyers and then become international lawyers. So we are already programmed into the basic program of thinking with a statist orientation. Even though that's the modern statist orientation that we are thinking through is very recent. It's late 19th century. So I'm saying, lift these blinds from your eyes. See the greater field in which the law of war is developed. Law of war, international law, criminal law as well. You get a richer perspective, can contribute even to the current discourse. So this is with regard to the temporal element. And with regard to the discursive element, I began with, I'm pushing for a specific position. For the customary, looking for the richer, and even more now, putting that approach as far as possible back into the table and considering it as a serious...
Give terrorists a few W's then? I need to know, at the end of the day. I'm fighting over tomorrow. I'm busy. Okay, it's it.
So here's
there's a yes, no.
No, there's never. We are legal advice. It was ever. There are very few advices that I gave it for a simple yes or no. I always ask, okay, what you are trying to attain? So if I understand that my client, there's no chance. My client is the Israeli government. There's no chance that they are going to give POW status.
It's the Swiss government. They're very
okay.
Nice. They're Swiss.
Yeah,
they're lovely.
But this is the
yes.
The answer is yes.
Exactly. It's a theoretical question for them.
What? Swiss or Dutch?
No, Swiss. Very sophisticated Swiss military. They still guard the They guard the Pope. The Swiss guard the Pope.
Just from another research that I didn't learn an answer to the question.
But they need to know there's a terrorist who's going to attack the Pope. It's Swiss. I promise I give you an answer in a moment. But just to know the Swiss and the pacifism, you know why the Swiss flag is red. What's the meaning, the actual historical meaning of the red color in the Swiss flag? Give no quarter. Okay. It was the refrain, it was a sign of we the Swiss never give quarter. Don't mess with the Swiss. Okay.
Yes. But now we return to the answer. So if it's the American government, they made the decision. They gave, for half a century, they gave POW status. What's nice about Shamgar's summary is that he applies very elegantly as far as possible. He says, you've decided that you are not going to give POW status. You decided that you are not going to prosecute them. So the only option that is left on the table is to apply the law regarding administrative detention of occupied territories, even though it's not an occupied territory, based on the as far as possible doctrine. So it's always with a client, with a legal client. There's the law. There are few things that are clearly forbidden. There are few things that are clearly permitted, and then you have this gray area. Within this gray area, your client chooses once he drew that note of the head. With that option that he chose comes certain duties and obligations and so on. It's never completely discretionary. And that's what nice about the Shamgar summary. It says, okay, you close these doors, this is the only door that is left open. If you left it open, if you are the Americans in Vietnam, okay, let's talk about you decided to give POW status, let's see where you're not giving it. So war criminals, no. People that did terror attacks in civilian markets, no. But people that convict the 5 criteria of the Geneva Conventions are iffy, not here. I cannot get so iffy, okay? Yes, so it's always, I know that's, when I was a legal advisor, that is how you go. You go with there's clear no, there's clear yes, and in the middle, there are options. Once the client chose an option, again, it limits the kinds of action that the client can do.
Thank you. We're getting to the conclusion part.
No, it's your, I looked at the statement, it says you need the concluding
I'm not Professor Amnon Reichman yet.
First of all, I want to begin by thanking people. I think that if we are in the realm of methodology, there's always a question of how legal scholarship develops. Should it be developed by the dictates of the world in the sense of, hey, here's my treaty, and writing my treaty, and use some wisdom and knowledge, and, or should it be developed by workshops of young scholars whereby you interact with some of the old folks, but mainly you interact as part, or we interact as part of the workshop, and interdisciplinary, in the sense that you bring people who understand something about morality, or something about political science, or we bring practitioners with theoreticians, or we make sure that it's people who are still young in the scholarly sense, which means that they're vibrant, they're interesting. Not to say that we've been calcified, but there's somewhere. And we've obviously decided to do this, to engage in this project. And from this door that we open, duties emerge, right? We just heard it. So we open the door, and once we open the door, duties emerge. So the duty is now to make sure that the discussions, discursive element that we've just had, comes to fruition in the sense of working papers, publications, further discourse, a gathering 2 years from now to commemorate the meeting we had 2 years hence, then 20 years down the road, remember the beautiful Haifa meeting that we had. So that the duties that emerge in terms of the continuation of the discourse, in order to make sure that it is a fun scholarly endeavor, and it's on all of wood, and that's nice, but there's also some continuation of our thinking projects. So this is with respect to methodology. Now, thanks with respect to people. I want to thank you, Bill. I want to thank you, because there's a lot of work involved for you. Of course, thank the Minerva Foundation and the Max Planck Society for the funding, which is always important. And Lily, of course, Lily is the overarching. She's in the roads now, enjoying the beaches of Greece. But she should be thankful. In terms of the substance, 2 or 3 words in terms of the substance. I still have to process it because, being old and calcified, it takes me some time to engage. But I challenge us to see whether we can draw some observations or insights regarding themes that cross people's presentation. So to the extent that there's something about the partiality, state, non-state, from a moral perspective, how does it apply to the question of, does it apply to the question of the dyadic notion of groans versus, because clearly there's some, because we value ourselves more than we value, it's legitimate, we value ourselves more than we value. There's tension between this approach and the idea, no, we should retain equality among fighters in terms of race. Okay, so, just an example. I mean, maybe it's valid, maybe the example is valid, maybe it's invalid. But I challenge us, which is, the idea of, okay, so should we think treaty-based understanding of what are the, or should we go grant principles and discursive? And as soon as we go grant principles and discursive, and look at the client, then the law evolves differently than trying to really distill the elements of the treaty and work with the categories of what is terrorist versus foreign fighter, however we want to call it. The international crime of terror. So I challenge us to think outside the scope of our, which sometimes in a way contradicts what I just said, because I urged you to publish, I urge you to write the work, which means narrow down, narrowing in. But at the same time, I urge all of us to take from this workshop the insights that cross the boundaries of what we do. To the extent, here's another example. We've heard about the inviolability, whatever it was called, of UN targets. Right? We've heard that to the extent the treaty language is such that UN facilities and personnel are set aside, and there's a unique provision set only for them. Then we've heard, in that lecture as well, that it defies the purpose, or that it grounds, so there's a purposive element that is introduced to the interpretation. It doesn't make sense if this has to fit into IHL generally, for various reasons that I'm not going to go into now because we've heard the lecture. So the language of the treaty should be interpreted to mean something other than the language of the treaty by way of introducing some exceptions. Unless they're misused or some other language that makes that particular section fit into the grander design of IHL. But question mark. Does that mean now that we should let go of the language and say, therefore, we should treat the United Nations just as we treat all other specially protected targets, despite the fact that the language there is clearly different, because there is an explicit unless, usually. This is the debate that we were having. So one way to go about it was to introduce by customary law, to say, well, why do we have all those hang-ups with the language of the treaty? Let's look at the purpose, let's look at the customary law underneath or beneath or somewhere in the background, wherever you want to situate it, and we should work with that. But the positivists, us lawyers, we say, yeah, but still we should give some weight to the fact that we drafted the protection in a way that is different from the way they drafted other protections. But then but that's a problem, because then we should have a third category, which is the position the UN argues for, complete off-the-limit, all other protected targets, and this third category, which is something unique about the UN, but not fully protected. So this business of creating other categories is what I'm aiming at. There's a tension in the discussion a general tension in the discussion that I learned from. It's people's dialectic relationship to categories. On the one hand, this is IHL, and therefore categories really matter. Because it's the do's and don'ts of war, because it's our culture as IHLists to work with categories, and as soon as we let go of categories, we have this, that means that everything is up to discourse, and people might argue positions because of clients, and morality will kick in, and what is evil to begin with, and we'll feel uncomfortable here. Categories, please, categories, and where you sit is where you stand, because this nation says that nation, you have to speak to countries. Of course, cultural boundaries. But these categories sometimes run in contradiction to the underlying purpose of the category. So what do? Do we allow ourselves to develop IHL and create new categories? Or what do we do with it? Do we create a new category of a right for competence? That's a new category. That's a new. If there is a new category in IHL, it is the right to life during war, not before. During war, there's the right to life of competence. It's a new category. But you came to this conclusion because you said the underlying purpose of this, that, and the other doesn't fit, so we have to have this. And others have said, well, as soon as you develop this category, I'm going to develop my own category. You're going to develop your category. So once you let go of, so there's a sense of how do we deal with developments in IHL, which I think cuts across the board. this is to tell me that I've been talking too long, and to transfer maybe some other people want to, I think this is maybe, some other people want to reflect on the experience, some insights of the experience we've just gone through, what we take from it, what some other people want to comment on how they see the road ahead, or how it has transformed their take on things. So actually
say that in the Minerva Center, in the last summer, we've done 3 work in progress workshops. One in cyber, one in constitutional law, and this is the third one. I was in charge of the first one and the last one, and I saw it on, he worked us on video, this is the constitutional one, so I got that to stay at home and just watch it. But I have to say that the added value of these small conferences, couple of days here in the cyber event, like 2 weeks, in order to let the people coming from abroad to experience Haifa a little bit more, and added value from the discussion. We just discussed that on lunch. The added value from having young researchers and trying to argue that Robert and I are still young, at least as researchers. And
That's why I came. The honor.
because I forced you.
That's the other one.
And to add guest lectures and respondents and have a full roundtable discussion. I was criticized for arguing that this is from a casual dress. I mean, business casual. And I explained to them that my version of business casual is make sure that you won't come with a tie. You should dress up. But the whole idea, have a relaxed version, to have a roundtable discussion, as opposed to a full formal conference when you give a lecture and you receive a few comments and then you move on. But have a full conference to be able to talk about it on lunch, to be able to talk about things over dinner, to have a very long experience is far more beneficial than everything I've had especially in the 2 years I've been here at the Minerva Center, but I think even more than that. In the last summer, I've seen so much more added value. And I think it also includes the workshop we've been in Bar-Ilan, in Castellona, and a relaxed version, a relaxed workshop. And I think if in my next years at the Minerva Center, I'm going to push towards much more this kind of events, this kind of experiences, because I've gained a lot from it. I want to thank you for everything I've learned from you. I want to thank you for the comments for my presentation. And of course, thank all the guests that lecturers that came to hear, either from far away or from abroad.
Somebody.
Oh, the center of Israel, Haifa, is further than Geneva to Haifa. This is
Services are better. EasyJet is better than Israeli train.
No, exactly.
So I want to thank you all for everything for the entire lecture.
If you have comments and you want to share, we can do it now, we can do it over, I don't want to tell you that Eddie's going to be there. Or you want to write us, how we can do this better, what can you gain, seriously. Like,
Can I say something really quick? So, I'm a lawyer. I haven't done law since I finished law school. Long. Actually, since I took my bar exam. And this was for me very refreshing. After doing a PhD in political theory and then using sociology, anthropology, political science, and political theory to analyze it. So to bring this back, I was a little bit concerned. I was thinking, oh my God, a lawyer hasn't seen this. It would be really interesting to get a legal take on it. And it was very, very useful for me. And I'm still processing the comments, and definitely I'm sure that it will be extremely helpful in turning this into a publication. So yeah, thank you for all of your comments.
should we go to Caesarea?
So this is
Okay.